On December 8, 2021, the Legislative Assembly of Alberta passed the Red Tape Reduction Implementation Act number 2. It was tabled at the legislature as Bill 80, which it was an omnibus bill, meaning it was a combination of so many pieces of legislation put together. So about 9 different pieces of legislation cutting across some 6 government departments. Within all of that, we had the amendments to the Alberta Human Rights Act. And most of the amendments I would categorize as amendments seeking efficiencies in the process of the commission, which is all good. For instance, the director of the commission was given a lot of flexibility to manage complaints. And the new section 21 really says that the director can, at any time, dismiss a complaint based on a number of grounds. There was a former section 22, which has been taken out or removed. And that section provided for an appeal to the Court of King's Bench now on certain grounds. That section was removed, and now there's only one avenue of appeal by way of judicial review. And that will be done in accordance with Alberta Rules of Court. So that's okay. Removing the 2-tier appeal system, reducing it to 1, I think that could be said to be, some sort of efficiency, and giving the director the ability to manage complaints. We all know how backlogged the Human Rights Commission or the complaint process is over there. On average, it takes about 5 years to have a complaint go from start to finish, and those will be the very lucky ones. So I don't think we can argue with that. But then there's this amendment that introduced a new clause. So prior to Bill 80, a complainant was required to show that there was a reasonable basis based on the evidence for a complaint to proceed to the next step. And that next step might be investigation, or in most cases, to a human rights tribunal. Now, the amendment has removed this reasonable basis standard and included a standard of reasonable prospect of success. And so what's the fuss about this? The Court of Appeal of Alberta had in the past laid a standard for interpreting or laid the principle for interpreting the standard expected of a complainant. And it's the case of MIS and MIS and Alberta Human Rights Commission. And just to paraphrase, the Court of Appeal said that reasonable basis in the evidence to proceed to the next stage would mean not as low as an arguable case, basically saying, oh, I have something going here, but it's also not as high as reasonable prospect of success. So the court refused to set a specific test, but this is the guide that the court provided at that time, or this was the guide. So the amendment now codified the higher standard that the court referenced in this decision by saying that the director can dismiss a complaint on any ground. There's a number of grounds, not just this one, but that the ground of the reasonable prospect of success is now part of what the director can consider as a basis for dismissal of a complaint. Why does this matter? Prior to the amendment, complainants, we are already having a hard time proving discrimination. And the 2020-2021 annual report of the Alberta Human Rights Commission, which is the latest to be published on its website, has some numbers. And when I looked at the report, it shows that over 70% of its complaints, the complaints it receives from members of the public, relate to employment practices, over 70%. We know that that is not an even playing field in terms of the power imbalance between the employer and the employee. So most of these complainants, we're already having a hard time providing evidence to support their complaint. And now this amendment, and that was under the reasonable basis standard. They have to show that there's a reasonable basis based on their evidence to take their complaint to the next stage. Now they have to show that their complaint has a reasonable prospect of success, which the Court of Appeal had said is a higher standard. Bear in mind that the mission of the Alberta Human Rights Commission is to protect public interest by ensuring access to justice. It's on their website, it's also on this annual report. Now, how does this ensure access to justice? I don't know. You know, it's one of the reasons why we are here. And before I go further, when I was trying to discuss this with my 12-year-old daughter at the time, she just turned 13, I was telling her to help me put what I'm thinking into a picture, into to give me a pictorial form of what I was thinking, to help me process my thoughts. And she came up with something which I thought was interesting. So while we wait for the picture, simply what this amendment means. Oh, here we go. Okay. So the black line would be the pre-Bill 80 status, the reasonable basis, which complainants would have to show for their complaint to make it to the next stage. Then B80, according to my daughter, raise the notches. You can see where the red line is. And from where I'm sitting, I don't know that any of those folks, any of them is happy. I don't think they're happy at all with that. But that's the picture that my daughter drew. So you can take it away, thanks. Okay, so that's the situation that we are in with respect to that amendment. And that's why we are here today, to have a conversation around that amendment.